A very old piece of legislation passed in the United Kingdom in 1780 and then imported into the Australian colonies made it unlawful to open up any house, room, or other place for public entertainment or amusement on Sunday, and to which persons shall be admitted by the payment of money or by tickets sold for money. Even by 1907, that law seemed outdated. Justice Higgins said, "I cannot but feel that the Act is not such an Act as public opinion in Victoria would permit in the present day." When laws no longer reflect community values, people find ways around them. Scott hired a large hall in Melbourne and put on concerts on Sunday evenings. He found a clever way around the law. There was no admission charge to enter the venue and watch the concert. Nobody was being charged to be admitted to the house, room, or other place. But then within that hall, there was an area called the reserve. About a third of the seats were in the reserve, and they were better seats with a better view. To get into the reserve, patrons had to pay, and that's how they generated revenue. Eventually, they were charged by the Fun Police, and it ended up in front of the High Court. The question was whether the reserve was a house, room, or other place. Now, this was a penal provision, an offence provision, and breaching it exposed a person to a criminal penalty. There was an old legal tradition which said that in the case of a penal provision, the provision should be read in favour of the accused, so any ambiguity should go in favour of the defendant. However, the end was coming for that philosophy. Justice Isaacs said, "Where Parliament has, in the public interest, thought fit to restrain private action and penalise a contravention, a court should be specially careful, in the view of the consequences on both sides, to ascertain and enforce the actual commands of the legislature, not weakening them in favour of private persons to the detriment of the public welfare, nor enlarging them as against the individuals towards whom they are directed." That remains the approach to construing penal provisions to this day. The role of the court is to do its utmost to identify the meaning of the statute given by the legislature and then to enforce that meaning.